The next case is in re JN. Each party will have 15 minutes to present their arguments. The appellant may reserve up to 5 minutes for rebuttal. If you do plan to reserve time, please let me know, as I will be keeping track of the time. The arguments are being recorded. When you present your argument, please introduce yourself, keep your voice up, and remain behind the podium. You should not use the name of children, minors, and victims during your argument. You can refer to them by initials or terms like the child. We have read your briefs and are ready to proceed when you are.
Morning, Your Honors. May it please the Court. Joseph Schell, Summit Legal Defenders, on behalf of the appellant here, Caitlin Calloway. Your Honors, I'll reserve 2 minutes for rebuttal. In this case, to reunify with her son, JN, Ms. Calloway did everything that she was supposed to. She reported JN's behavior to the police and then to the Child Services Agency. And then she worked her case plan, most importantly, obtaining the housing that was required of her, housing that she still has right now, today. The state, in moving to place JN in a planned permanent living arrangement, PPLA, did not do what it was supposed to. Specifically, it failed to present evidence of 2 statutory requirements under Section 2151, 415, C1C. And so accordingly, this Court should reverse. I plan to focus most of my presentation and argument here on the first assignment of error, on the PPLA, the sufficiency of the evidence argument. And I think that argument requires 2 sort of table-setting measures here. One is what the appropriate standard of review is here, and the second is exactly which statute applies. So starting with the standard of review, the agency seems to suggest that only manifest weight review is available here, not sufficiency of the evidence, but the Ohio Supreme Court in re ZC said that's just wrong. In paragraph 11 of that decision, what it said was, when we're talking about juvenile court or custody statutes, and it requires the trial court to find clear and convincing evidence that certain statutory requirements are met, that the sufficiency of the evidence and the manifest weight standard of review is the appropriate standard, quote, depending on the nature of the party's arguments. And here Ms. Calloway has raised both of those challenges, sufficiency of the evidence as well as manifest weight. The agency has, I think, ignored all of our sufficiency of the evidence arguments and only focused on manifest weight. But sufficiency is the correct standard given that we've raised that kind of a challenge. Now the second issue is what statute applies here. Is it 2151-415 or is it 2151-353? And there's 3 reasons why 415 is the right statute here. The first is that the agency conceded that it was. That's what it filed its motion under in the trial court. That's at record page 62. The second is just the text of these statutes. If you look at 353, the entire thing, maybe with one exception, subsection, is about initial adjudications. Initially, what are you asking the disposition for at that first adjudication hearing?
But when Mother filed objections, her objections were all made under Section 353, right? She didn't object at all to, I think it's 415.
Yeah. So I think that's mostly right, Your Honor. I think that yes, like she did target 353 for the most part. I think it wasn't clear though that subsection C was in play though until the trial court issued its decision. So in our objections below, right, we said it's not really clear what
But
subsection.
Isn't it clear because that was the motion? The motion said it was that section in PPLA. So wouldn't it be that standard that we're talking about at the hearing?
So I think that is the standard that we were probably under the impression of going into the hearing. The magistrate's decision, though, I think muddied those waters, and then the trial court cleared it up again by proceeding explicitly under subsection C. The reason that matters specifically, though, with subsection C is that it's the only one between these 2 statutory requirements that requires something different in 415 as opposed to 353. Otherwise, those 2 are the same. And I think our insufficiency challenge preserves this issue via the objections.
In Mother's objections, though, does she challenge the things that you challenged on appeal?
So I think one of them explicitly, yes. So certainly the unwilling, I think the unwilling or unable to accept is captured in that sufficiency challenge explicitly. But again, I think part of it is that it wasn't clear what the magistrate was doing, whether it was proceeding under subsection A, B, or C. Not until the trial court issued its decision was it clear that C was the one that it was proceeding under. So getting back to the text of 415, though, I think clearly controls here because it explicitly, in subsection A, right, like targets this exact situation. It says when an agency has been given temporary custody, and then it later moves for a different disposition at the end of that temporary custody period, which is exactly where we were when the agency filed its PPLA motion, that 415 controls. And 415 subsection C then prohibits the court, says the court shall not place a child in a PPLA unless it finds by clear and convincing evidence three things. First, that the child is 16 years old, that it's in the best interest of the child, and that then one, either A, B, or C, applies. The trial court made it clear that it was proceeding under C. The second district in Re WJS, which the agency cites on its brief at page 6, actually has a helpful explanation of why 415 controls in these situations, does a good job of explaining the interplay between 353 and 415, and that's at paragraphs 18 and 30 of that decision. And what it says in paragraph 30 there is that 415A clearly applies to post-adjudication situations where an agency has previously received temporary custody. So 415 is the arena that we're playing in here. So I think with a table set there, the merits of this assignment of error challenge the two requirements in 415C1C. And that requires that the agency show that JN was in an agency-sponsored independent living program, and secondly, that he was unwilling to accept or unable to adapt to any other permanent placement option.
But did Mother challenge that specifically in objections, that prong?
So, no, it wasn't clear to us that that was what the magistrate was proceeding under. It was more so just, it was a general sufficiency of the evidence challenge. I think that preserves it. I think if we're talking about similarly to what this court has said about Rule 29, I think we're in the same kind of context here. So that sufficiency of the evidence preserves it. Now, on whether the child was in an independent living program, again, in the agency's brief, to place Jan in a PPLA, it concedes that he was not.
But it doesn't say that in the statute that the child has to be in an independent living. It doesn't specifically say, it says preparing for independent living, right?
So no, I think the text of the statute, Your Honor, in 415C1C, I've got it right here, says that requires that the child has been counseled on the permanent placement options available, is unwilling to accept or unable to adapt to a permanent placement, and is in an agency program preparing for independent living.
Preparing for independent living. So those are two different things, right? Being in an agency program and preparing for independent living. It doesn't mean the child currently needs to be in an independent living, right?
Doesn't need to be in independent living, no, but does need to be in a program that's preparing him for independent living. And that's what the agency conceded he was not in.
I guess if you interpret it broadly, it doesn't say that you have to be in a program preparing for independent living. It says you have to be in an agency program and preparing for independent living. If you read that broadly, right, wouldn't it be that he's 16 and he's preparing for independent living? And certainly isn't he in a program he's in a therapeutic foster placement at this point, right?
He's in a foster placement, but I think the way that the other courts, and especially WJS takes this on as well, and reads that as one phrase, where everything is connected. It's not two phrases. It's not in an agency program and separately preparing for independent living. It is a program that is preparing him for independent living.
So if there are people, for example, that have a special need that they need to be institutionalized, and they're in a program, an institutionalized program that can never get PPL unless they were in something like Safe Landings, something that purpose was to prepare you for adulthood? If you read that narrowly, that's what you would say. It would only be in those kinds of situations where PPLA would be available.
So I'm not sure. So if somebody needs to be institutionalized, which again is not what we're dealing with here. Like
right.
No one's arguing that JN needs to be.
But do you think that historically PPLA is used for all of those situations?
So
like severely autistic people going to institutionalized settings, PPLA situation, but they don't necessarily have to be a program preparing for, like an independent, like a safe landings where it is a preparing for adulthood.
So yeah, I don't think the statute specifies exactly, which program it has to be, but it does have to be a program that's preparing him for independent living. I think that comes straight from the statute's
And
text.
how's the trial court supposed to explore that if it's never objected to? Like, if we don't know the details in the record about what program he was in, or whether that was preparing him for independent living.
So one thing the record does not demonstrate that he was in an agency-sponsored program that was preparing him for independent living. The closest that it gets is that in some of the case plan updates, there's a note that he sometimes gets education from at the foster home about how to live independently.
Okay.
But what the agent...
So wouldn't that be preparing for independent living, or no?
It is preparing for independent living. It's not an agency program that's preparing him for independent living. And Your Honor, the main reason that we know that is because the agency said that it would begin the process to place him in that program when it filed his PPLA motion.
Again, don't you think that's a narrow reading of the sentence? It says, in an agency program preparing for independent living. So aren't those two separate, couldn't that be broadly read as two separate things? In an agency program preparing for independent living.
No, I think not based on the way that the statute is written. We've got a comma and then an and then the rest of that clause follows unbroken. And so I think that's one specific thing. And again, the best evidence that he was not in that is that the agency said it wasn't.
Do you have any case law interpreting that specific statute?
So WJS does talk about that statute. It talks about it in the plain error context, and it does in fact find in that case that that child was not placed in an agency program. They read it, the second district reads it as in an agency program that is preparing him for independent living, as all one concept there. No case law directly from this court, but WJS I think is the best option for that. And so since the agency had conceded that below, that he was not in that, they would begin the process of placing him in there. And then in the appellate brief, the agency points to no other evidence that he was in fact in such a program. So that statutory element is not met, and the court should reverse on that ground alone. But the other part of 415C1C is also not met here, that JN was unwilling to accept or unable to adapt to other permanent placement options. In fact, the testimony says the exact opposite. The agency's caseworker testified, page 16 of the transcript, that JN both wants to go home and live with Ms. Calloway, with his mom, and that he's content in foster care.
But doesn't the child victim also live with mom?
Yes.
So isn't that an issue about unable to?
No, I think it's a different logistical question. It's certainly part of, it could be part of, I think on the second assignment of error, it's a little bit more relevant to how likely reunification is, but strictly on the statutory requirements, what the agency is required to show by clear and convincing evidence to the trial court, in order for the court to order PPLA, it's got to be that JN is unwilling to accept a permanent placement option.
Or unable.
Or unable to adapt.
Right.
And I think adapt carries with it a behavioral connotation there. It's not, is he unable to physically be in a place?
So if a person has perpetrated a potential sex offense on one of the residents, couldn't that possibly be construed as being unable to adapt to that setting?
It
or
could be.
If you are potentially a child sex offender, maybe not be able to adapt, unable to adapt to a setting where there are children in the household?
So it certainly could be, but it's not here because of what the testimony shows. JN's guardian ad litem testified that he was not likely to reoffend, that he knows that he messed up, that he wants to be reunited with his family, and he knows what to do. The guardian ad litem further testified that the younger sister, who was the victim, was also not uncomfortable with JN being there, knows what to do if something happened again, and and is comfortable reporting any sort of suspect behavior later on.
You're in your rebuttal time. Did you want to?
Oh, I'm sorry, Your Honors. No, I'll reserve the rest of my time for rebuttal. Thank you.
Thank you, Your Honor. May it please the court. My name is Aaron Campbell. I represent Summit County Children's Services in this matter. The agency respectfully asks this court to affirm the decision of the trial court that awarded planned permanent living arrangement to to the Children's Services, or PPLA. Now, I first want to address the legal authority for awarding PPLA that is largely considered under the first assignment of error. The agency does not dispute that 415 clearly applies to situations where we're in a sunset dispositional setting. The agency filed its motion requesting PPLA under 415. That certainly, there is a prong there that applies to this. But the court is not limited under 415 to only those dispositional options. When a motion to modify any of its prior dispositional orders has been made, and that's what the agency's motion was in this case. It was a motion to modify its temporary custody to basically legal custody under PPLA. And that is what some other case law has found, that, and especially in the matter of IMM, is that this is a change in status from a temporary legal custody situation to just legal custody of children's services.
I guess I'm not understanding that. Isn't that what 415 is all about?
Yes, Your Honor, that certainly applies. 415, the court can consider that motion under 415, but that's not the exclusive authority that the court has to consider dispositional options.
Okay, so you're saying that there is the inherent right of the court to put a 16-year-old child in PPLA.
That is something that the court has the authority to do under 353.
Isn't there a case law that talks about how that this is an extreme, situation and is not to be interpreted broadly, and the court has to follow the PPLA requirements?
I would agree that this is a situation that is not desirable in case it's long-term foster care, and ultimately the agency would not want to have a situation that's long-term foster care. It would like to reunify or somewhat otherwise create a permanent placement for the child. But when there are no other options, that is...
How was there no other options when the foster parent said that she was more than willing to keep him at her house?
Well, under PPLA or any other temporary orders, that's essentially the same thing. The PPLA would ensure that the child remains in foster care and...
But not in a home environment.
It wouldn't be any different situation under PPLA versus temporary custody of the children's services. The only thing that changes under either a 6-month extension or PPLA is that PPLA is considered a final order.
Okay, so he would still be able to stay with the foster mother?
That is a possibility, and the parents do not lose their legal rights under PPLA.
Well, they wouldn't with legal custody to a foster parent either.
That's correct, but the foster parent did not request legal custody in this situation.
Did anyone talk to her? Was anything on the record about that, since she said that she was willing to keep the child?
That's when she was willing to keep the child, but it was, I don't know that there was specific testimony about that the foster parent wanted legal custody herself. That's a very different arrangement for a foster caregiver to accept legal custody versus either adoption or maintaining just temporary foster placement.
What are the options with PPLA, since you said that foster parent is one option?
Well, under PPLA, the child remains in the legal custody of children's services, so the situation largely remains the same. The agency has the right of placement under that situation or under that scheme. However, the court maintains jurisdiction of the child and still maintains reviews over the child's placement, and the parents are typically involved in those reviews. If there's a change in placement, the parents are notified, just as if the agency held temporary custody or permanent custody.
I guess I'm just confused because a significant portion of the brief is talking about the child's best interest under the second assignment of error, at least. And the child had said he either wants to go to mom or he wants to stay with his foster parent. So the impression that I got when I was reading it, that was not an option, to stay with the foster parent.
So there is no guarantee under PPLA that the child remains with that specific foster placement. It is a custodial decision that the agency could make, but there was no indication from the record that there was any need to change that placement.
I'm sorry. With PPLA, the burden of the finances stays on the state, right? Like he's in a therapeutic foster home versus if he goes to permanent legal custody to a foster parent or something, where that would become their burden, right?
That's correct.
So that would ensure, PPLA would ensure that he receives therapy.
That's correct. There are significant financial differences for a legal custodian to take custody of a child versus the child remaining in the
Right.
agency's custody.
Is he in a therapeutic foster home?
I believe so. I believe
I
the
don't
child
remember
was-
reading that in the brief, so that's what I'm trying to.
I believe the child was in the
Judge
village.
Lansing knows a lot more about this than I do, but I'm just trying to figure out what's going on. I know he was in therapy and so forth, but.
I recall testimony that he was, at least at some point in the village network. I don't know if it's in the record whether that's specifically stated that that is a therapeutic foster home, that is typically a therapeutic foster arrangement for a child.
Thank you.
So under dispositional hearings, the court has certainly the authority under 415 to consider PPLA under that section of the statute. However, because this is a motion to modify custody, 353F2 as well as Juvenile Rule 34G requires that the court hold that dispositional hearing as if it was the original dispositional hearing. And that means the dispositional requirements under 353 also apply, and the court has the authority to award under 353A any of the dispositional options under 353A. That would include PPLA under that section. Now, the key differences between 353A5 and 415C1 are that under C1C, there's an extra requirement that the child be in an agency program preparing for independent living. Now, that doesn't require that it be a specific independent living program. There was some evidence in the record that it was not considered at the actual hearing that the child was in independent living. For example, the admitted case plan demonstrated that. However, that wasn't presented at the hearing itself, that he was specifically in an independent living program. But that statute shouldn't be read that narrowly. The child is in counseling.
Then why did CSB say that it intended to enroll him in an independent living program?
Unfortunately, that information wasn't presented at the hearing. It was.
Could you talk just a little bit louder?
Absolutely, I'm sorry. It doesn't appear that that information was presented at the hearing. It does seem that the child was involved in counseling through the therapeutic foster home. That may be something that was discussed through, or something that could be provided through that program as well. It's not clear from the record whether or not the child was receiving that or not. But
Well, if it's not clear, it's by clear and convincing evidence.
That's correct, Your Honor. And what I mean specifically is whether or not that was specific program was an independent living program.
But isn't that the whole point?
But the statute doesn't require that the child specifically be in an independent living program. It requires the child to be in an agency program preparing for independent living. And there's no dispute in this case, the child was involved in agency programming, and that was the ultimate goal of PPLA.
So I'm just trying to figure out, I'm sorry to be cutting you off. I wouldn't be that rude in ordinary life, but we only have limited time, so I apologize to you. But then what was the need for CSB to enroll him in a program to begin preparation for an independent living?
The agency does have a separate and specific independent living program, but unfortunately, what the agency meant by that in its motion was just not clear from the record. However, that requirement is only found under 415C1C. That is not found under 353A5. That only requires that the child has been counseled on the permanent placement options and is either unwilling or unable to adapt to the permanent placement here. And that's the main issue that the court found in its decision under 353 is that one of those prongs applies. This prong certainly applies in that this youth has a younger sister in the home who was the victim of inappropriate sexual contact from this child, and there was still a no contact order in place between those two children. No one at this point had requested that that no contact order be lifted, and it wasn't required under the case plan. It was still a significant consideration from the court is that the mother testified in this case that she wasn't even sure whether that younger sister was wanting her perpetrator to
But
come back.
doesn't that
into the
come
home.
into play aside from the requirements of the statute?
It's a best interest factor, Your Honor. It
And
would
the
also
best
apply.
interest factor of the child that's being placed, not necessarily the best interest of another child. Now, don't get me wrong, obviously, you have to obey court orders and children should not be placed in a position of vulnerability, but doesn't the statute talk of best interest of the child that's being placed, which would be JN here?
That's correct, Your Honor. It would be the youth involved in this case. But that best interest factor is the interrelationship and interactions with significant people in that child's life. And that would include his interaction and relationship with his victim, who is his younger sister as well.
So that would come into play, you're saying, to say, well, it's not in his best interest because they don't get along, because there might be another offense, there might be da-da-da. Okay, so what about the foster parent?
I'm not.
Well, you say it's not in his best interest to go back to mom's place. Okay, that I understand your argument. What about the foster parent? Why is it not in his best interest to stay there?
But the agency believes that it is in his best interest to remain with that foster parent. The placement in PPLA doesn't change the placement situation. That would remain in place unless the agency provides notice that the placement was going to change. They would have to notify the parent as well that they're changing placement, and the parent would have the ability to come in and object to that. So there is, the award of PPLA doesn't mean that that placement's changing. The agency would argue that they're keeping this child with the foster parent, and that's in his best interest to remain there.
It's unfortunate that wasn't in the briefs.
I apologize, Your
No,
Honor.
I'm just saying because I got a completely different image of what was being presented, that's all.
But I want to clarify, it's not required that the agency keep that foster placement, but the PPLA just does not mean that foster placement changes at all. The only thing that really changes in this award is that it's a status change from temporary to a final order where the agency has legal custody. If there's going to be any changes to the placement in foster care, the agency would have to give notice, and potentially the parties can object to that. That could also be grounds for the mother later requesting that the child be placed in her legal custody. As under PPLA, that's not a termination of legal rights. So the mother has the option to later demonstrate a showing of changed circumstances and request legal custody to her. And that's not really any different under a 6-month extension either. She would still have to later prove, if she wanted legal custody, that the situation has changed, she's remedied the problem, and it's in the child's best interest to be placed with her. So fundamentally, there is not a significant difference between the child remaining in the temporary legal custody of Children's Services versus an order of PPLA.
Is it your position, I know you're running out of time, is it your position that they have not reserved this issue for appeal?
That was not something that was raised in the brief. I believe that was largely encompassed in what was objected to below, and that there was a sufficiency of the evidence objection, but that was not something that the agency had raised in its brief in this case. So lastly here, as my time is running out, I just want to briefly touch on the second assignment of error. That is an award of 6 months extension of temporary custody. That's an abuse of discretion standard in this case. The agency has kindly raised throughout this case that a parent does not have the standing to raise that. And this case presents the unique opportunity to prepare the case, or to compare the case law on PPLA and a 6-month extension. The language used for both under 415 is substantially similar. And the Ohio Supreme Court has stated directly in Ray AB that standing for PPLA is limited to just Children's Services. The agency believes that that is also the same language must be applied to standing for a 6-month extension. This court need not address that if the court affirms the decision of PPLA, because only one dispositional option can be in the best interest of the child. But if the court's going to overturn or sustain the first assignment of error, the agency would first ask that the court consider standing for the 6-month extension of temporary custody. The agency believes that that is the same for PPLA. So the agency would ask this court to affirm the decision below. Thank you.
Thank you. You have a minute and a half.
Thank you, Your Honor. 4 quick points on rebuttal. Judge Cart, you're absolutely right that what the Supreme Court of Ohio said in 2006 in Re AB at paragraph 36 is that PPLA is a last resort for placing a child. So yes, this is an extreme situation and it requires the statutes to be construed strictly. Second point, 353F2 is not about it does not open up different dispositional options under 415. In fact, the case that the agency relies on, in Re WJS, explains that what it takes F2 to be doing there is to make sure that the same procedural protections that are available at the initial disposition are available when the court is hearing a motion under 415. Third, much of the agency's argument today was based on, well, that could have been presented. Well, it's not really clear from the record whether that placement option was available. That dooms the trial court's finding that there was clear and convincing evidence that a PPLA was appropriate. It was the agency's burden to present that evidence, and it did not do so as it conceded here today. And fourth, and relatedly, talking about that this foster placement could be a permanent placement dooms the PPLA motion. Under 1C1, the requirement is, and this is under 353 also, right? It requires that JN is unwilling to accept or unable to adapt to other permanent placement options. It is the agency's burden to rule them out. And if there is another one, as Judge Carr got to with foster placement, then PPLA is not the appropriate, is not the last resort.
And you're out of time, so if you could wrap up in 10 seconds?
Yeah, thank you very much, Your Honors. We would just ask you to reverse trial court's order. Thank you.
The court will take the matter under advisement and issue a decision in due course. The clerk of courts will mail you a copy of the decision on the day it's released. The opinions are also posted on the Ohio Supreme Court website. Thank you both for your presentations.